Hi everyone, for everyone that's new here, welcome to Legalese. We are a fixed fee legal advisory and we operate all across the country. If you want to know any information about us, our team, and our service offering, you can go to our website, which is legalese.co.za. So today's webinar is the Promotion of Access to Information Act, which is PAIA. And as much as I know POPI has been on everybody's minds for the last few months, please do not confuse the two. So POPI is the Protection of Personal Information Act, and PAIA is the Promotion of Access to Information Act. And although they sound similar and they are a bit related, they cover two different areas of law. That being said, hi everyone, my name is Lauren and I am a data and commercial lawyer here at Legalese. And I'll be taking you through the webinar today about PAIA and things that you need to know. For today's webinar, I hope to cover 4 broad topics of PAIA, which should assist everyone in understanding a little bit about it and a little bit of what is required of you. So firstly, I'd like to discuss the background of PAIA, the reason it was enacted, a little bit of its history. Then I'd like to move on to private bodies and part 3 of PAIA, which deals with all the aspects related to private bodies and how PAIA relates to them. Thirdly, I'd like to discuss updates to PAIA, updates to the Act and regulations which are pertinent to private bodies going forward. Lastly, I'd like to discuss PAIA compliance and what you'll need to do and need to know to ensure that you are compliant with PAIA going forward. Firstly, before we start, don't freak out. Legalese is here to help you. And hopefully this webinar guides you and you take something away from it. So, background to PAIA. PAIA was enacted to give effect to Section 32 of the Constitution, which is the right to access to information. PAIA recognized that the apartheid regime perpetuated a culture of secrecy and abuse of power, and it sought to move away from that into a culture of transparency and accountability. This is also relevant in today's time where people are alive to the value and importance of information and also demand transparency from businesses, from government, and just in everyday dealings. It's important to note that PAIA applies to the exclusion of any and all legislation that prohibits access to information. PAIA trumps it all, and following the guidance of PAIA, information should be available. So following the structure of the Constitution, PAIA differentiates between public and private bodies. For our purposes today, we'll be discussing things that focus on private bodies, as these relate to companies and partnerships and generally juristic entities. Part 3, so the access to records of private bodies. Section 50 of PAIA deals with the right of access to records of private bodies. There are 3 aspects which are important to someone requesting access to a record of a private body. The Section 50 states that a requester must be given access to a record of a private body if A, that record is required for the exercise and protection of any rights, B, where that person complies with procedural requirements in the Act relating to the application, and C, they must be given access if the record is not refused in terms of any of the grounds of refusal. So what do these 3 elements mean? Firstly, the exercise or protection of any right. Generally, there's no definitive answer as to what this means or what this means specifically. The courts have taken it to be interpreted on a case-by-case basis, and each case will be considered on its facts. The Constitutional Court has said generally that a person that seeks the information, they must establish that it's advantageous to them or that there's an element of need, that they need the information to protect their right. What we do know for sure is that the exercise of protection of any right does not mean a fishing expedition. It doesn't mean a competitor looking to swim around in your records or information about your business. It also doesn't mean vexatious applications of people just trying for nefarious reasons to gain access to information. Secondly, an application for access to information must comply with the procedural requirements. So firstly, a request must be made in the form that corresponds substantially to that of Form 2 of the regulations. This might seem complicated, but we'll discuss a bit about the regulations later. Essentially, an application must either be the actual Form 2 which is available, or should genuinely and substantively have the same information as that of Form 2. Secondly, an application for access to information incurs a fee. So for private bodies, an application fee is 140 Rand, and a requester must pay this fee to the private body before they gain access. The fee is for the private body to even consider the application. If the application is denied, the fee is returned to the requester. Thirdly, the grounds for refusal. As you can see, there are 7 grounds for refusal, and we're going to go through them briefly and just touch on what they mean and what they relate to. So firstly, mandatory protection of the privacy of a third party who's a natural person. Essentially, any information that is unreasonable to the personal information, unreasonable to disclose the personal information of a private person and is not allowed. This also includes a deceased individual. So information that is unreasonable to anyone who is passed on is also not allowed. Secondly, mandatory protection of commercial information of a third party. So a private body must deny request for information, commercial information of a third party, and the commercial information includes things such as trade secrets, financial, commercial, scientific information, things that would disadvantage that third party in commercial negotiations or dealings, or information that might prejudice competition with that third party. Thirdly, there's a mandatory protection of certain confidential information of a third party. So this, as in the term confidential, relates to information that is protected through confidentiality in terms of agreement. This could be generally an agreement or even through a non-disclosure agreement. Information that is protected in this manner cannot be disclosed. 4, mandatory protection of safety of individuals and protection of property. So where a private body with access to information of a private body could reasonably be expected to endanger someone's life or their physical safety, the information must be denied. There's also an element of protection of physical, like buildings or things like that, but that is an optional refusal. So 5th, mandatory protection of records privileged from production in legal proceedings. So this is a very long way to say that information that is subject to attorney-client confidentiality cannot be disclosed. So any information you share with your attorney or your lawyer, ordinarily that would not be disclosed, cannot be disclosed under PAIA. 6, mandatory protection of research information of third party and protection of research information of a private body. So this protection means that a private body must deny access to a record of research where the research is carried out by a third party, and the access to the record would disclose information of that third party, what they are researching about, and anything written in them, as well as if the private body is researching themselves, that research is also protected. And then lastly, there's an optional refusal for commercial information of the private body. As mentioned earlier, commercial information of a third party is a mandatory protection. However, commercial information of the private body itself is an optional protection. The private body has an option to deny requests where it feels that the information includes, trade secrets, financial or commercial scientific information, as mentioned earlier, if it relates to negotiations or if it would prejudice that private body in competition. An important ground for refusal that private bodies should note is what's called deemed refusal. So under Section 58 of PAIA, if the head of a private body just fails to respond within the time period allowed, which is 30 days, that private body is regarded as having refused the request. So although there are all these grounds for refusal, silence is also a ground for refusal by a private body, and this is only applicable to private bodies. So, but what happens if you refuse a request? We'll discuss a little bit later about who the information regulator is and where they come to play. However, a request who has been denied by a private body has a right to complain to the information regulator. The information regulator has dispute resolution powers, and they may investigate the complaint, assist in resolving the complaint, or make a decision as to whether the private body should approve the request, deny the request, or any sorts of action like that. Next, updates to PAIA, the Act, and the regulations. So very recently, as we discussed earlier, PAIA was amended by the Protection of Personal Information Act, which is POPI, to include the powers of the information regulator. So who is the information regulator? Well, the information regulator is a body who's been tasked with monitoring and enforcing compliance with POPI, and now as well as PAIA, in the name, information regulator. So they deal with all the aspects in relation to POPI and information about POPI, and then now as well as PAIA. Next, the PAIA regulation. So on the 27th of August 2021, new PAIA regulations were published. But to step back a bit, what are regulations? Well, regulations are essentially laws or directives which are created in terms of an act of law. Because legislation itself is quite static and goes through a rigorous process to amend it and publish it, regulations are published to allow for more dynamic changes and updates over time. So what's new about the PAIA regulations? Well, the new regulations repeal and replace the previous regulations that were issued and include a few updates that are relevant to private bodies. So in the new regulations, these are all the updates that are coming in. The information regulator must publish a PAIA guide, and both the information regulator and the head of the private body must make it available. But what is a PAIA guide? Well, a PAIA guide should not be confused with a PAIA manual. A PAIA guide is a guide which is prepared by the information regulator that contains information that is needed to help or assist anyone looking to exercise their rights under PAIA. It's a guide essentially to help understand PAIA, how to do PAIA requests, and anything related thereto. Secondly, private bodies can disclose certain records and make them automatically available. So private bodies have the option to make information actively available without a request. They have the option to do this, and they can decide which records they feel they should be available automatically and open to the public. Thirdly, the head of a private body or private body in general has to inform a requester of their decision and, if applicable, the fees regarding a request. And as we mentioned earlier, the regulations provide for the various forms in relation to PAIA requests, informing of the outcome of requests, and various other forms that are applicable to PAIA and the actions that can be performed thereunder. The regulations also provide for the fees for requests. As mentioned earlier, the fee for making a request to a private body, which is 140 Rand. The regulations also provide for a dispute resolution mechanism. As discussed a bit earlier, these are the powers of the information regulator and what they can do to assist parties where there's a dispute in relation to requests. So compliance. What is actually required of private bodies? So Section 51 of PAIA requires that a head of a private body must make a PAIA manual available, firstly on its website if it has one, secondly at its place of business, and thirdly to anyone who requests a copy if they pay a reasonable amount, and lastly to the information regulator when they request. We've been talking a lot about what the head of a private company is, private body, and just to explain, in the case of a company, a CEO or someone authorized by them is the head of the private body. If you've already performed compliance under POPI and designated an information officer, the information officer also could count under PAIA. It's the same position, and they can be by the same person. So, what is a PAIA manual? Well, Section 51 states what should be included in the PAIA manual. So we can run through them broadly and discuss generally what should be in. So firstly, company information and contact information. So this includes information about the CEO, or as mentioned, the information officer, any deputy information officer. It also includes information about the company, its premises, its address, things like that. Secondly, a PAIA manual must include information on the PAIA guide. It's very important that a PAIA manual has information to allow any requester, possible requester, to ascertain where they can obtain a PAIA guide, where the private body provides this. It could be on their website, in their offices, etc. Thirdly, a description of any records which are freely available. As you mentioned, a private body can make records freely available, but it must also be remembered that certain records are automatically freely available. Things such as the company's memorandum of incorporation. That's a document that is available as it's accessible on the CIPC's website. Things, although we are discussing it, a PAIA manual should be freely available by the company. Fourthly, the manual must contain information on the processing of personal information. As I discussed, POPI and PAIA are interrelated, although different. So PAIA manual needs to discuss information on processing of personal information. This includes categories of the private body's data subjects. It may also include the third parties to whom the private body provides information of their data subjects. Things that are generally related to POPI should also be included. And lastly, the PAIA manual should include its availability. As we mentioned, PAIA manual needs to be available on the company's website or in the place of business, and the PAIA manual should state as much. So, why didn't private bodies have PAIA manual before? Well, since the start and enactment of PAIA, private bodies have been exempt from compiling a PAIA manual. But that's all changed. In terms of a government gazette that was published on the 30th of June 2021, the exemption for private bodies is coming to an end on 31 December 2021. That means as of 1 January 2022, all private bodies must have a PAIA manual published on the website or available at the office. So you might be thinking, well, what happens if I don't? So there are certain sanctions for non-compliance with PAIA. These include, firstly, where someone has the intention to deny the right of access by destroying a record, damaging a record, concealing a record, or falsifying information, they may face a fine or imprisonment not exceeding 2 years. Importantly, a head of a private body who willfully, so knowingly, or grossly, in a gross negligent manner, fails to comply with the provisions of Section 51, which is the preparing of a PAIA manual, they may face a fine or imprisonment for a period not exceeding 2 years. And lastly, non-compliance with an enforcement notice may also face a fine or imprisonment. What is an enforcement notice? Well, an enforcement notice, as mentioned earlier, the information regulator has dispute resolution powers, and an enforcement notice is a notice which the information regulator may serve on the body. The notice may confirm, amend, or set aside a decision that the body has made in relation to a request, or the notice may require the information officer or head of the private body to take action or refuse to take action in respect of the request. Beyond the topics or the sanctions mentioned above, there's also the aspect of reputational harm for non-compliance. We are in an age where people are aware of the power of data and information, and it reflects badly on a business who disregards these aspects, disregards the importance of being transparent and open in their dealings. For example, there was a case where a private body was involved in steelworks and that which had a massive environmental impact. They received a request for access to information. The court, they denied the request and the matter was taken to court. The court in the end sided with the requester on the basis that the company had put itself to be committed to engaging with environmental activists, to be open to negotiations and talking with them, but in practice had denied or blatantly denied a PAIA request. And the court found that you could not perpetuate yourself to be open to negotiation, doing things, but in practice of denying requests, especially in that case, regarding the importance of the environment and the impact on the environment that the company's dealings had. So, to conclude, PAIA compliance is not as daunting as it seems, and I hope, albeit quickly and through this session, you've maybe learned a bit about what's needed from you. And if anything, I hope that you take away these lead tenets from what I've discussed. Now, firstly, ensure that you have a copy of the Information Regulator's PAIA guide. It's easily accessible. You can obtain it through the Information Regulator's website. This is one of the big tenets, and it's important that you just simply have it available on the website and even a copy in your office. Secondly, ensure by 31 December 2021, you have a PAIA manual. There's strong talk that the extension or exemption will not be extended again, and it's up to private bodies to be compliant by this date. And three, be aware of PAIA applications. Albeit broadly, we've discussed generally the tenets of a PAIA application. Be aware of them and what the process entails. We're not saying that you might be flooded with them immediately, but it's good to be aware of what it means and what you can and cannot do, and the reasons why you can and cannot deny. So thank you everyone for joining, and remember you can contact us at Legalese at any of on our website and any of the information here. If you have any questions, feel free to ask them, pop them in the chat function, and I'll see if I do my best to answer. Let's do this. There you go. See, there are 3 questions. Okay. That's a good. Thank you, Mark Bennett. That's a good question. Thank you. I do not believe that it's VAT applicable, as that's not specifically provided for, but I would like to research that a bit more. That's actually an excellent question. If you'd like to get into contact with us about that, we can confirm that answer for you. I see there's only the one question. I'll just give it a bit to see if anyone else has any questions. No? Thank you. So all the pricing is available on our website. You can contact, it's available on our website, and we have a pricing option for preparing a new PAIA manual, as well as reviewing a current PAIA manual. Just give it a few minutes in case anyone else has any other questions. Okay. Thank you, everyone. Thank you so much for joining, and I hope this has cleared up PAIA a bit for everyone. Thank you. Goodbye. Remember, you can contact Legalese at legalese.co.za, and we'll be available should you need.